it seems like most of y'all have enough basis to know that a protective order carries criminal consequences. Accordingly, that makes it a pretty heavy tool in negotiating a divorce. So I would encourage you very strongly, if you have one of those cases, to do the protective order as part of your case. It gives you more leverage in negotiating settlement. It often will help your case to do it. You'll get evidence that will be just as applicable in the divorce. It'll leverage onto your divorce, and you can file it into the divorce. The other thing that I find, if you file it into yours, a lot of times you can get better results. A lot of times you can leverage it for a better settlement. And I understand what you're saying about if they're poor, we don't want to charge them more billable hours. But I would think about if it will help your case in the long run.
So what we just heard was a criminal prosecutor, a county prosecutor, instructing attorneys on how to use protective orders to gain the upper hand in custody disputes. Critics of family court reform, which is typically judges and attorneys, will often say that false allegations don't happen very often. But there's a name for it, and it's called the silver bullet. So not only are false allegations a problem, but attorneys are training each other in how to use them as leverage. Besides the burden of proof and the evidentiary standard, another problem with family court is that courts only really rely on one standard, and that's called the best interest of the child standard.
In fact, what happens is in every state, there's some statute somewhere that says the family court should act in the best interest of the child. The problem is that the best interest of the child is not objective.
Every statute gives a list of factors for the court to consider when they're considering the best interest of the child, but there is no guidance for courts on how to weigh those factors. This is why two judges looking at the exact same factors in the exact same case can come to completely different conclusions. It's because it's not a defined standard. There is no statutory guidance on how to weigh those factors. And there's no guidance for courts on what is generally best for children.
There's debate about what is in the best interest of the child. So the question really should not be what is in the best interest of the child. The question should be who decides what is in the best interest of the child. When you have fit parents, judges should never decide what is in the best interest of the child.
What a lot of people don't realize is that the best interest of the child isn't an actual standard. It's just a list of criteria for the court to consider. But courts have no guidance on what to do with each of those factors. So how do you weigh them? And then what do you do with the information that you get out of the case? So one of the problems that the courts have is that they have to make a decision about what is best for a child. But best is very subjective. The best interest of the child is simply not defined. So courts have to apply their own opinions, their own biases, and their own ideas about how to raise a child. Because if you have two good parents, the court has to choose a parent that is best for the child. There are situations where it's very obvious that maybe there's a parent who is a danger to their children. They should not have access to their children at all. What we're seeing, though, is that when there are two good parents coming into court, the court still has to pick someone. So good parents are being separated from their children simply because the court has to choose a parent. There's a big misconception that if you're a good parent and you go into family court, that you're going to be able to maintain that relationship with your child, that you're going to be able to continue to make decisions for your child, that if you're a safe, loving parent, you'll continue to be a parent. The problem is that is not how things typically work out. Typically, there's only one parent who is able to retain their parenting decision rights. Only one parent gets the majority of the time. And so one parent is automatically sidelined simply because the courts have to choose. And depending on which data point you're looking at, you could see that typically mothers are the custodial parent and typically fathers are not. So it's easy to say, hey, courts are biased against dads. But we are seeing more moms being separated from their children, again, simply because the court has to pick a parent, and that particular judge picks the dad. So I think the argument should not be about whether or not courts are biased, but really, in my opinion, the argument should be why are the courts allowed to be biased?